the Law Society of Ontario is thinking about scrapping the bar exams for future lawyers and is considering rather making, a training course. In other words, there would be no bar exam to determine if people have the substantive knowledge necessary to call themselves lawyers. And I really do think that that is hugely, hugely problematic. To my mind, it denotes a failure on a number of fronts. If you're putting forward people who do not have the substantive knowledge of the law and of legal principles, why would they be lawyers? Why would I go for legal advice for someone who doesn't know what they're talking about? Hello and welcome to the next episode of Beneath the Law. Gavin Tighe here with Stephen Thiele. Stephen Thiele, how are you doing?
I'm great, Gavin. How are you doing?
I'm hanging in there. I just came back from a week in the UK, which was wonderful. I'm feeling very civilized now at the heart of British civilization.
What, are you saying that Canadians are not civilized?
The bar and the guilds of the bar was all very, hoity-toity.
It sounds all very colonial.
It was I feel very colonial. I felt very colonial, but it did remind me, of course, of the great and long and proud history of the learned professions, of which the law was considered to be one.
Well, we're still a very learned profession, and I hope that we're still in a profession of high repute among most of the people in the public.
Well, that's a great question. I mean, I think that the repute of the legal profession has certainly suffered somewhat over the years. Many people have a view of the legal profession and the caliber of lawyers, both from a moral and intellectual perspective, that is perhaps not too flattering.
Well, look, I mean, within our own profession, there's certainly debate about incivility among lawyers within the profession. I don't know if that has to do with changes in attitude or changes in competencies or changes in who is admitted to the bars of the provinces. There's lots of issues we're struggling with.
There are lots of issues. I do think that, one of the things that is important is that, being a lawyer has to mean something. To me, I don't think it's just sort of anyone can be a lawyer, nor do I think that anyone should be a lawyer. I think that there has to be some standard and some like quite high standards for the legal profession, as with any of the old learned professions, including medicine or what have you. Simply because I think for two reasons. First of all, I think that it's important that the public has a respect for the profession and has confidence in the skill and knowledge of the profession, and maybe more selfishly, I think that it should be an achievement. I mean, I think that when a young person is called to the bar in Ontario or anywhere else, they should feel proud of themselves. They should feel like they've really achieved something that is not easy to do, and that they have reached a level of learning and recognition within society that is something that they have earned and they're proud of. So for both reasons, I think that it is important, in my mind, that the profession and practitioners of the law have a certain caliber and have certain standards.
Yeah, I'm not so concerned about a person graduating from law school not being proud of their accomplishment. What I'm a little bit more concerned about, and you and I went to law school in and around the same period of time, or so almost same year of call. What I'm concerned about more is that legal education has become watered down in some respects, and that the skill sets of our new lawyers coming into the profession are not as strong as when we graduated from law school and were called to the bar. That we were trained with more substantive knowledge and were trained on other skills that make up a good lawyer, such as negotiation skills or oral advocacy skills, and had that kind of experience and training. And I'm just not sure that it's the same anymore. And I don't know what your views are on that, but my son is in law school right now, and it's interesting hearing from him in terms of the differences in the approach to what was legal research 30 years ago.
Yeah, I mean, legal research is one. I mean, it's an interesting question. First of all, let's just sort of back up and put into context what we're talking about. And what is come out in the news recently is that the Law Society of Ontario is thinking about scrapping the bar exams for future lawyers, and is considering rather making a training course that lawyers go to. In other words, there would be no bar exam, there would be no testing in the old-fashioned way to determine if people have the substantive knowledge necessary to call themselves lawyers. And I really do think that is hugely problematic. And I think fundamentally, it to my mind, it denotes a failure on a number of fronts. If you're putting forward people who do not have the substantive knowledge of the law and of legal principles, why would they be lawyers? Why would I go to for advice, legal advice, for someone who doesn't know what they're talking about? I mean, and the other question is, the failure you bring up is the substantive knowledge used to be the job of law schools to teach lawyers substantive law. I mean, and I know first year law school was really hard, because you were learning, um, basically trying to learn a whole series of cases and concepts. You had to be able to remember the cases and what the cases stood for, and to be and you get a problem on your exam, and you'd have to be able to analyze that, refer to cases, write an essay that answered the question as to what, giving the advice or what have you, in a specific problem. That was a law school exam, a classic law school exam. And I don't know, these days, whether or not young people or young students or law students are being forced to go through that rigor. Rather, I don't know if it's sort of substantive law that they're being trained in, or more sort of a philosophical approach to, concepts of justice or concept of all sorts of other things. But I think that the technical kind of substantive legal training is lacking to some extent. And unfortunately, maybe that's the reason why now they're saying, well, we can't have a bar exam, because too many people are frankly not going to pass it because they don't have the knowledge to pass the bar exam.
There's been a change in philosophy over the decades, for sure. You may recollect that when we attended the bar admission course, we did it in three separate phases. There was a first phase that taught negotiation skills, practice on a motion to test your oral advocacy skills. There was a much more skills based approach to what a lawyer does. And then we did our articles. And after the articles were finished, I think we were 2 or 3 months at the bar admission course, learning about substantive law in several topic areas, real estate, business, public law, civil litigation, etc. And it's changed now. So all you have some law schools where you actually don't even need to article anymore. You can just write your bar and pass that way. You have others where you still have a traditional articling program, but then they've done away with the skills based teaching, and the bar admission course. There are only the exams, sorry, are only two exams now: one barrister exam, one solicitor's exam, and they're 4.5 hours long, and they're multiple choice. So you're actually not answering questions, in a traditional sense.
I mean, I kind of feel like the old guy in the Muppets here. We're like, when I was a kid, we did, though you did it this. But I mean,
Well, we're
honestly,
up preaching from the
and
balcony.
and I think that, I mean, coming back to your point, but I actually think of it from a different perspective. I think of it like from the perspective of the public, there has to be an obligation on the licensing body of any profession to ensure that the practitioners of that profession have the necessary knowledge, skills, and tools to properly practice the profession. I mean, think about that. Think about this in a different context. Let's say we were talking about doctors and we were saying, oh, well, we're going to let you do a multiple choice exam. You can hang out your shingle to be a doctor. And people were going to that and they didn't know they didn't know anything. They didn't know anatomy. They didn't know pharmacology. They didn't know the usual skills that a doctor is expected to know. I mean, no one would agree with that. Everyone would go, what? Absolutely not. Lawyers, and we see it all the time in our practices because we do a lot of lawyer negligence work. Lawyers can lead people into real, I mean, you talk about physical disasters that a doctor could lead somebody into. Lawyers lead people into absolute disasters in terms of financially, their lives are ruined. People go bankrupt. It's lawyers can be very, very destructive and have an enormous amount of ability to harm the public. So, to my mind, it's an obligation of any regulator to protect the public and ensure that the practitioners of any profession meet minimum standards of competency before that person can hang themselves out and represent themselves to the public as being knowledgeable about something. How and the regulator has an obligation to ensure that they are knowledgeable. And how else do you do that other than a test?
Well, a test that actually teaches substantive knowledge. I mean, your comparison to the medical profession is actually a good one because what the Law Society wants to do is focus examinations on subjects like client relationships. So, do we have medical exams that focus on are you a doctor who has a good bedside manner? Is that an appropriate test
Well,
for
maybe. I mean, I don't think there's
uh,
anything wrong. I mean, look, it's good to have a doctor with good bedside manner, sure, but I think it's better to have a doctor that knows which prescription is going to fit this symptom or how to read a blood test.
right?
Um,
But that's what they're trying to do. What it appears the Law Society is intent on doing is to get rid of examinations that test whether you actually understand the law and the legal principles, whether you understand how to do that. Again, in comparison to the medical profession, uh, read that blood test.
Yeah, I mean, and
So
I actually think that it's the baseline knowledge like that baseline basic knowledge that separates you from everyone else. I mean, the reality of it is we all know there's all different kinds of lawyers and there's all different kinds of doctors. And then, and many, sometimes some people don't need bedside manners. If your job, for example, is, I don't know, analyzing a tax problem and you never have to actually talk to people, you just review and draft like some kind of arrangement that deals with a specific tax issue. If you whether you can talk to people or whether you can be a good client developer is irrelevant. The question is you've got to have really substantive knowledge of tax law, etc., in order to do that practice. So, but it's a baseline thing. It's not a skill that is applied to all. And every lawyer, in my opinion, should have certain basic baseline understanding of basic legal principles at a minimum, and the knowledge in picking up on your legal research point, the ability to know how to learn other aspects of law that they don't know properly and thoroughly should they encounter it in their practice, or to know what they don't know, in other words, to refer it off to somebody else who does know that.
right, but it's as I said in terms of my read of what the Law Society of Ontario is proposing, moves away from that, and quite frankly, I think it puts the public at risk in terms of putting lawyers or passing lawyers or calling them to the bar who don't have sufficient background. And we're seeing it already, Gavin, in terms of the use of artificial intelligence, which seems to be a runaway train, and lawyers, quite frankly, no, not many lawyers, but we're beginning to see lawyers relying on large language models and putting before the court cases that don't exist.
Yeah.
And like that to me is the fear that moving away from substantive law and on these other skills, anybody can learn those other skills, and then we're putting them forward into the profession. And it seems to be, it seems to be a little bit reactionary to a particular group of law candidates who actually are not trained here in Canada, but are trained in other countries.
Yeah, I mean, I don't, look, I think that that's another whole issue. I mean, I've always had trouble with this concept because law is not is like medicine in some ways, but it's not like medicine in a lot of other ways. Anatomy is anatomy. If I studied anatomy in Russia, the anatomy is the same as it would be if I studied it in Toronto. The law of physics is the same in Uzbekistan as in Manitoba. Um, so someone who was trained as a physician, the basic skills of understanding of how to practice medicine and the basic, if they are equivalent, indeed equivalent, are the same. If I'm an engineer, I mean, a bridge is going to fall down in Uzbekistan the same as it's going to fall down in Manitoba. So um, those things are the same, but law is different. Law is different here than it is in South America. It's different here than it is in Japan. Very different. So someone who was trained in substantive law in Japan, for example, um, would not necessarily understand um, legal concepts and the law of Ontario. So the notion that they could be transplanted from wherever to Ontario strikes me as being bizarre. Different than somebody who's a graduate of a well-regarded engineering school in a foreign country could. I could I in my opinion could likely make a transition quite easily to anywhere because the rules are the same in terms of physics. The rules are the same in terms of anatomy, but they're not the same in terms of law.
No, the law's different everywhere else. We have common law, we have civil law.
And
Um,
many other
uh,
types of law.
Absolutely, you have Sharia law. You have all kinds of different laws. You have law schools, or the way that a person is allowed to apply to a law school in some countries, uh, is different than in Canada. Normally you need to have your undergraduate degree. You need to write a proficiency test, uh, before you even go to law school. In some other countries, you're just applying to law school right out of high school.
In the UK, you go right out of high school.
So, so there are different approaches to that as well that can impact, your basic knowledge as a lawyer and your ability to actually apply the law to various issues that come before you.
Yeah, I couldn't. I think that that's just a matter of common sense. That the rules and regulations and laws of Ontario are going to be different than they are of somewhere else. They're probably going to be very similar, if not identical, to most common law provinces in Canada. In fact, for the most part, most of the statutes are word for word the same. But they're going to be very different than, for example, if you were trained in, I could pick your country. If you were trained in Scotland, the laws in Scotland are going to be very different than they are in the law of Ontario. Even though the Scottish legal system, based on the British legal system, and the Ontario legal system is based on the British legal system, probably have a lot in common. They're not the same. Someone who's qualified to practice law in Scotland can't necessarily walk, out of Pearson Airport and open a law office and be advising people on the law of Ontario.
Well, there will be greater similarities between you know uh, trained lawyers from some countries than other countries.
Sure,
And look, I mean, the reality is, everybody who applies to be a member of the Ontario Bar should not necessarily be passed.
I agree with that too.
And so, what my view when I read through the report and the recommendations from the Law Society seem to suggest is that everybody from anywhere who wants to apply to practice law in Ontario should be allowed to pass more easily than they're passing right now.
Yeah.
We've got a rate of some candidates, particularly the national accredited candidates, who are passing at a rate of barely 50%. And so now we've got the Law Society reacting to that, that we must somehow accommodate that particular group more than others. And I just think it's going to water down the profession, and I think it's going to harm the public interest. And the other point that I want to make is, Gavin, I read through the report, and it's something like only 10 pages long in terms of this fundamental change to the program that the Law Society is proposing. I mean, they're asking for comments from the profession right now, uh, and I would have expected a much more robust report um, uh, in terms of looking at these fundamental changes rather than what I read.
No, but I come back to my point earlier. I think that being a lawyer has to mean something. And you said some people have to fail. It's I'm sorry, but the reality of all aspects of human endeavor is that if no one can fail, then no one can succeed. And the reality of that is it's got to mean something both to the public and to the individual that they have actually achieved something that is capable of not being achieved by somebody else. Otherwise, it's a meaningless exercise. We're back to there's no winners and losers. Everyone's just a participant. But I mean, ultimately, that does not breed in excellence and the level of professionalism that I think that the public has a right to expect from the legal profession.
I agree with you, and I get back to this point in terms of reading the report. I would have liked to have seen more information because there are some provinces, Alberta, Saskatchewan, Nova Scotia, Manitoba, that have moved to a different model of examination. But in terms of what I was reading, this bare summary, it seems that at least they have not discarded a substantive component from their examinations, or from their process in terms of calling lawyers in those provinces. And I think that's important to retain. And I don't see that. I could be wrong the way that I read it, but I didn't see that in the current LSO model. I
You know,
just think we're just moving too far away from that.
and I look at it from another perspective. I mean, I actually think that it is shameful. The number of lawyers, first of all, I don't know that we need, frankly, a lot more lawyers per capita. I think that part of, it is arguable that that the legal marketplace is saturated. And I think all you have to do is find and there are any number of them that are out there, young people with no articling positions, they've no job. They're scratching around to try to pay a whack of student debt that they've incurred having gone to law school in Canada. This is not even talking about people from foreign jurisdictions, um, and really have no ability to make a living as a lawyer, because the market is just saturated. There are too many, frankly, probably too many lawyers. It's far, far too expensive for most people. More lawyers is not necessarily the answer because it is very difficult to run a law practice, and not charge people what is for most people an enormous amount of money just because you can't run an office. That's the only source of revenue for a law office is what the lawyer charges on an hourly rate. So, it's really unfair, I think, for law schools. And I put the onus back on the law schools, that they are pushing through so many candidates with this illusion that there's this great future ahead, which is guaranteed income, which is not necessarily the case. And you've seen it. They've established, for example, I know several years ago I taught at it that they had a practicum program for those who could not find articling positions, and that just struck me. It just struck me as tragic that these poor, for the most part, kids had gone through 3 years of very expensive post-secondary education only to find that they didn't have a job at the end of the tunnel. And I don't know what the statistics are, but that's an enormous cost to those individuals on what is frankly an illusion of a future career. And I think that the law society and the law schools would be far more um, uh, honest with those people if they were fair to them and said, listen, no, many are called, but few are chosen. And you need to understand that. And that is not something that is guaranteed. So before you make that investment in your future, be wise with it.
Right, but again, what we've seen is the reaction is we have now two law programs in Ontario, one at TMU and the other at Lakehead University, that you can go into a stream there and essentially avoid that articling process. You don't need that job. You just write your exams, and there you go. You're now a member of the bar if you pass.
Or now there won't be
So
an exam. It'll just be you remember
well,
everyone's
it'll
a
be
member of
this
the bar.
skills-based, self-taught through virtual modules, with some, I guess, instruction at some point in time. But it's unclear how the testing will actually be carried out from the proposal. I mean, I didn't see that in the 10 pages or 11 pages that were devoted to changing the way that the bar admission course is going to work. I mean, there could be great instructors, but again,
And there could be great students. I mean, the reality of that is that I don't think that necessarily is. It means that you are not going to be a fine law student and a terrific lawyer. Um, I think that I don't know that eliminating a test is going to keep out the next Clarence Darrow out of the bar. I think the reality is that if you're going to be a great lawyer, you probably do quite well on the test. So a test is nothing to be feared from someone who is prepared to take it.
I just Gavin, as I get older, I'm not going to be one of those practitioners that hangs on in the profession until I'm 80 or 75 or perhaps even 65. um, I want to give opportunities to younger lawyers to get into the profession, and practicing forever, in my view, is a barrier. But what I am concerned about is that we are moving away from a merit-based um, uh, testing system or examination, and that it just, to me, is a complete danger that we're just watering all of that down.
Yeah, I know, and I before we leave the topic, I think we fully agree on this, but I do think that the profession has some responsibility too, and I think that one of the aspects of that is articling, and one of the things is articling jobs. It was really a cop out by the profession. The truth is that articling, you don't make money generally speaking on your articling students. I mean, it is a cost, but it is an obligation of senior lawyers to mentor and help and teach um, younger lawyers how to practice law. And that's what articling was always about. That's the old guilds and the apprenticeships and the rest of it. You learn by doing, you learn from senior people. So, having senior lawyers around to teach you, I mean, I know that I benefited from it enormously. I had the great fortune of having some really terrific mentors in my career. And frankly, I don't think I would be anywhere near the career that I've had, but for those people. And so I think that the profession has an obligation too. And it's not just to say, well, I don't want to pay for articling students, so I'm not going to I'm not going to have an articling program anymore. They can go get their practicum test at whatever, and I don't have to worry about that. I think the profession has an obligation to ensure that too. But the bar is just that. And when they talk about lowering the bar, and now they're talking about eliminating the bar, then anybody can get through the bar, and that can't be in the public interest.
That almost sounds like no, nobody is above the law, then everybody's beneath it.
Kind of sounds like it, and that's exactly what it's about. Thank you all for listening. A great topic, a great point of discussion. I'm sure there are many people who disagree with us on this. And if you do, I'd love to hear from you with your thoughts and your comments. And Always enjoy a debate, where the facts and opinions are discussed and open and aired. And generally speaking, quite frankly, as with the adversarial system that we all operate in, the right answer often comes from pieces of both sides of an argument. So, Stephen, thanks very much. And always remember, if no one is above the law, then everyone is beneath it.